All right, good morning, Remax Distinctive. It's Dan Bouchard Fernandez with the DC update, the broker update. And today we've got a little bit of a different presentation for you. A number of our agents have been encountering a lot of rental deals going on in the District of Columbia. And lately, that seems to be happening more and more now. And where we are encountering a lot of gaps that we have been missing. And so we're going to discuss some of the new laws that have changed in DC. So we're going to jump right into it here. In particular, what we're going to talk about today, of course, I'm not an attorney. Talk to your associate broker or whatever. Anyways, we're talking about today is Title 42, which is the Real Estate Act. And then Chapter 32 within that is the Landlord and Tenant Act. And so this is the law that we're talking about. It was amended recently as of March of last year. And it really added a lot of new requirements, and we're not even going to cover all of them. We're going to cover as much as we can, but we're going to jump right into it here. So it's a tenant screening. So the first thing that I'd really like to get you to understand is that before requesting any information or fees from a prospective tenant, as a part of tenant screening, a housing provider shall first notify the prospective tenant in writing or by posting in a manner accessible to a tenant, to a prospective tenant. So before you can start qualifying a buyer, before you can ask them to fill out an application or do a rent spree or anything like that, in writing, you've got to send them a disclosure that describes everything that we're going to be talking about here today. So in writing, it's a documentation, and you're going to be probably overwhelmed with the content of what is required. I will tell you that I have prepared this disclosure for my own personal use, but we haven't released it or discussed it really with Andrew or the rest of the broker team. And it's not off, and it is not a disclosure that is being presented by the Real Estate Commission. It is not being provided by the City Council. The City Council and the Real Estate Commission are not talking to each other about this. So though the City Council has made this law and made this requirement, they've not directed the Real Estate Commission to devise any content to administer it. So we're going to talk about it. I recognize there's a gap there in the communication and there's a gap in documentation, but we've got to talk about the law so that we're in compliance. And I just want to make sure that we are squared away. So we've got to prepare a document that discloses a bunch of things. So that's the key to where we are. So before you start screening them, before you start asking them any questions, the first thing you got to do is give them this disclosure. What I'm doing is I'm emailing it to them as soon as I get a contact that says, I want to see 123 Main Street. I'm emailing them this disclosure filled out with all the information. Now, this is coming from the perspective if you are a landlord or if you are a licensee, either property manager or a real estate agent. So, so what it says is before requesting any information from a prospective tenant, as a housing provider, so a housing provider in DC law means a landlord and or the property manager and or a licensee. All right, the amount and purpose of each fee. So you got to state in your disclosure the amount of the fee for their screening, and what the purpose of it is, exactly what it is that we're going to be using it for. So this is a rent spree fee that we are charging $50 for, and it's going to be used to verify your credit and your other criteria. So the types of information that will be accessed to conduct this tenant screening. So you're going to articulate to them that we are going to be looking at your credit history, and we're going to be checking your references as you dictate. And this is what we're going to be looking for to check you out. We're not going to be looking for your credit score, although that may pop up on the document. We're not going to be looking at the credit score and using that as a determination, because we'll see later on that that's a violation. We can't use that in Washington, D.C. The next thing that we have to do is the specific criteria that will be an automatic denial. You have to state in your disclosure exactly what is going to be a denial criteria. So we are not going to accept you if you have 3 late pays on your credit card. We are not going to accept you if you've got whatever your other criteria are. You've got to detail the specific criteria that will be used to deny an application. And again, if we are licensees at RE/MAX Distinctive, we're not doing property management, so this decision is our landlord's decision. It's not our decision as licensees. And so the landlord will be making the decision, but we are going to be guiding our landlords that this is what you have to use in terms of denying an application. So you got to tell them what the criteria is going to be listed. Say, these are the 5 things that we're going to deny your application based on. Next, any additional criteria that may result in the denial of the application. So any additional things besides the top main ones that could pop up that may result in a denial. So the maybes might be something that might come up. So you've got to tell them what those maybes might be as well. Next, and this list goes on. It's a very exhaustive list. So we're going to go through as much of it as we can here in a few minutes, but I want everybody to understand these things. All of this has to be done in writing in order to satisfy the law. So we've got to go ahead and state that the name of the consumer credit reporting agency. So if we're going to be using RentSpree, we know that RentSpree uses TransUnion. So you've got to say, we're going to be using RentSpree as a service provider, and RentSpree uses TransUnion. So your credit report from TransUnion was going to be what we're going to use to qualify you. And a statement of the prospective tenant's rights to obtain a free copy. So we have to disclose to the tenant in writing that they are entitled to receive a free copy of that. That's critically important. The approximate quantity of the rental units. Now, this item number 6 is going to be something that's going to be required for multifamily property owners. So anybody that owns more than 2 properties in Washington, D.C. is going to have to take into consideration the number of rental units that will be available over a specified period of time. So, but under normal circumstances for us agents in RE/MAX Distinctive, number 6 usually won't apply unless you're representing an apartment complex or something like that. Andrew might have a specific situation that number 6 might apply to, but I want to focus on number 7 here in particular. The number of days after receipt of the prospective tenant. So when in the disclosure, you have to state that we're going to give you an answer to your application within X amount of days. You have to state that up front and tell the prospective applicant that you're going to give them an answer, a yes or no, an approval or a denial within X number of days. And you have to abide by that. And you'll see where that comes into play here in a minute. The next item is number 8, the prospective tenant's right to dispute any information relied upon by the housing provider that is inaccurate. So if there's anything that's in the, anything that they obtain either in your references or in the credit reports that might be erroneous or anything like that, the tenant has a right to dispute it and to ask you for a reconsideration of a negative decision. So you've got to be able to state that in writing to the tenant. I know that this is a lot of material that I'm throwing at you, and this is what the law is, but we've only scratched the surface here. So let's continue to jump into a couple more of these things. The prospective tenant right to a refund of any unused application fee. So I don't know, RentSpree I think charges $49.95, I think, is what the fee is. If you've collected $50, number 9 says that we have to refund that 5 cents back to the tenant. you can't keep that as part of the process. So if you've collected $50, you can't keep the $50. You can only keep the $49 and they will pay the fee for that. So if you're using RentSpree, this is automatic. So we don't have to worry about crediting anybody back. But if you're using another service like a paper rental application, and I believe that we are not using paper rental applications in our company. I believe Granny's put out a notice a few months ago that said that we're only authorizing the use of RentSpree and other online platforms like that. Andrew, you can correct me if I'm wrong.
Nope.
That was a yes, we're okay. That's true.
Yeah.
Okay. The prospective tenant's right to file a complaint with the Office of Human Rights. So this is so if they don't like the way that you have presented the case to them, either to accept them or to deny them, they have a right to go and file a complaint with the Office of Human Rights, either with an attorney representing them or not. They can do that individually if they want to. And I will tell you that if you do get a violation notice on any of these kinds of things, it's going to come from the Office of Human Rights. They are the recipient of they are the clearinghouse recipient in Washington, D.C. for all of these kinds of complaints. And so we want to avoid that. And even the appearance of discrimination can launch an investigation and a complaint process. So that's a cumbersome, tedious, and frustrating process that usually involves having to pay out some money. So we want to avoid that. All right, Section 10B1, a housing provider may require a respective tenant to pay an application fee, which will be no more than $50. Now, this was enacted in 2023, but since then, they have there's a secondary provision of this that says that the CPI of at the time of the application, you may increase that amount based on the CPI. It's a complicated procedure that incrementally increases the amount of the application fee moving forward from 2023. So it's peanuts. So for safety's sake, I would just say, don't collect more than $50 and you'll be safe. Just play it safe and don't collect more than you're required to, because even if you don't use that money, all of the money for the credit report, you have to refund it back anyways. So just collect what the cost is. If the service that you're using charges greater than the $50 or the CPI index of that, then you have to refund that money back to the tenant, even though you may have expended that money for that credit report. So if they're charging you $75 to do the credit report, DC law says you're basically only allowed $50 plus the CPI index. Stop me if you've got any questions so far. Anybody have questions? Well, let's stop. Does anybody have any questions so far on any of this content?
So Dan, when I use RentSpree, it's really difficult to understand from RentSpree how long they're going to take, because they're going through all the information and they're calling people depending on those people returning calls. So it's taken up to 3 weeks to get a complete RentSpree application completed.
What's the question? You're breaking up, Shafiq. I can't hear you.
I'm sorry. I said if RentSpree takes up to 3 weeks to get that information to you, you tell them 3 weeks?
Well, I would probably give a longer date, a longer period of time to get an answer to them. Absolutely. So that to give yourself that time to comply with the law. But it doesn't say that you can't deliver an earlier notice, but you have to deliver the notice either accepting it or declining it within that deadline. So yeah, I would say yes. I would give myself a little bit longer time frame.
And the other issue with rent spree is that it's not share the person's social security number and their driver's license.
Right. Yeah.
And if you, as a landlord, need to go to tenant landlord court for whatever reason, or you need to go to Superior Court to file for anything, you need that information.
Well, that's not covered in this law. That's kind of a little bit outside the scope of this law. And we got a lot of content here. So, I mean, I hate to defer that comment, but I just want to just talk about the law and the requirements of this. That's kind of going into a rabbit hole. So I'd like to put a pin in that conversation and let's come back to it another time. All right? All right.
Okay.
Section C, if a housing provider fails to conduct a screening of a respective applicant for any reason, the housing provider shall refund any application fee paid by the prospective tenant within a reasonable time, not to exceed 14 days. So this wouldn't apply in a rent spree situation because they're paying it automatically and they're already doing it up front, except if you are not, if you're not going to screen them and review the screening, review the rent spree application, then you'd have to refund the money that they paid. Even if the fee's already paid by the tenant, you would have to refund the money anyhow back to them out of your own funds, and that would not, and rent spree is probably not going to give you that. They're not going to credit you for that. So just be aware of that. That's just what the law is saying. Next, housing provider shall not base an adverse action solely on a prospective tenant's credit score. So we can't base the decision. Stay away from the credit score altogether. It says it can be considered as a factor, as a part of the overall picture, but you can't point to the credit score itself and say this is the reason why we denied you your application, because your credit score was too low. In my suggestion, my recommendation is don't even discuss, don't even look at, don't even mention the credit score at all, and you will be in better safe territory to not even consider it. That's my recommendation. Obviously, Andrew can contradict me if he wants, but that's my recommendation. Don't even talk about, don't even look at, don't even consider the credit score itself. Look at the content of the credit report, not the credit score. It shall not be construed as a violation of this section if a housing provider receives a credit consumer report containing information that may not be used as the basis of an adverse action. An adverse action is a denial. So when we're denying them, that's an adverse action. Pursuant to subsection D of this section, provided that the housing provider did not specifically request or inquire about this information and can demonstrate that he or she did not base an adverse action on such information. So if for example, the service provider that you used, let's say it wasn't rent spree. Rent spree gives you the ability, if for Washington, D.C. applications, it'll automatically remove the criminal background check, because criminal backgrounds are not allowed. But if you happen to be using another service and it happens to give you a criminal check as well in that report, this provision says that you will not be considered a violation of this section if the housing provider receives a credit report. If it happens to contain information that you can't use, that's fine, so long as you can document and prove that you didn't use that information, that negative criminal information or whatever it was, as a decision maker in your decision. So make sure though that, I mean, this is a dispositive proof that we have to make, and so it's really hard to defend yourself if you can't document and say the reason we denied you was this, this, and this, and it wasn't this other thing that wasn't supposed to be on your credit report. Any questions about that? I'm just going to go over a couple more, and so that's basically that's the end of the presentation that I have. There are a lot of other requirements in this picture, but I want to make sure that you understand that the requirements just for screening are specific. You have to have that disclosure in writing before you ask them any questions about their qualifications. Do you have an agent? Do you have an agent? Yes, that's probably something that you can ask. Do you have, what is your credit score? No way, you can't ask that. You have provided this disclosure with all of these requirements in it before you can ask any kinds of questions whatsoever to qualify them. So I'd like to open it up for Q&A. Anybody have any questions, comments, or inquiries?
Hey, Dan, my only question is, you said you have created this for yourself, this like little form. Did you have attorneys review your form? I know it's not used for Remax Distinctive yet.
Yeah.
But
I did have 3 attorneys look at it, and I made some tweaks to it based on what they had said, and yes, but we'd have to discuss it internally.
Is this a form then that Andrew will allow agents
Not,
doing rentals in
as of this
DC
moment,
to use?
as of this moment, I have not addressed it with Andrew, so we'd have to talk about it.
Okay. Well,
yeah.
Needless to say, I'm walking away from that listing and the rental, so maybe they'll do it on their own.
Yeah. Yeah, if they don't follow these instructions, they could be held liable for this. These things and go to the and so the thing that I want to make sure that you can get a copy of this PowerPoint. I can email it when you get the recording of this class today. I've got a PowerPoint PDF and a PDF that you can follow and watch the links. So the links at the top of the page that I reference in the PowerPoint are the links that you can go to pull up the law itself. I forgot to point that out, but that is something that you can do. I would encourage you, specifically those of you who are working with multifamily properties, particularly Karstens, there's a lot more rules in this law, so I would encourage you to dive into the law deeper and read all of the requirements that go on. And I mean, it's quite lengthy. I only scratched the surface today. So anybody else have any questions on it?
I do not, Daniel. Thank you. That was very thorough, and appreciate the best practices, and look forward to the PowerPoint, just so we can actually break down all the points from today.
Sounds great. All right, thanks everybody. I know this went longer than normal, but this is very important, and we're going to do some more sessions similar to this moving forward with other parts of DC law that a lot of agents are just simply not aware of. So go ahead and hit the streets and let's go make some money.
Thank you, Dan.
Thanks, Dan.
All right. Take care.